We're back in Senate Judiciary, February 19th. We don't have Senator Perchlik here yet for S22, but we do have a clean copy of S3 in front of us related to transferring property to a trust. And I believe I mentioned last week that we were going to kind of just hold it open for a little bit in case there was anyone else who wanted to provide any testimony or follow up regarding it. I have not heard anything. So we do have Eric Fitzpatrick from the council here in case we have any final questions or comments on this bill. Committee, any final thoughts before we take a vote for Eric or just the committee in general?
No.
Okay. Great. So in that case, Senator Matos, if you could please, I would entertain a motion to vote this out favorably if there's anybody.
I would move that we vote out S3 draft 2.1 and inoculate the transfer of property to the trust.
Fantastic. Senator Matos, if you could call the roll, please.
Sure can. Senator Norris.
Yes.
Senator Vyhovsky.
Yes.
Senator Baruth. Senator Matos. Yes. Senator Hashim.
Yes.
401.
Fantastic. I can report this unless, like I said, somebody suddenly became super interested in reporting. But I'll take that as a no. So I can report this, and it sounds like it's going through the proofreaders. And once I get that copy, then I can run it upstairs to the secretary. Perfect. Thanks, Eric.
Yeah, thank you.
Senator Perchlik is not here. Thank you. I think we can get a walkthrough. We can start a walkthrough anyways because it's 11:17. Does Senator Perchlik know?
Yeah, you did, but I can give it on you.
Okay. Yeah, Eric, if you want to just start the walkthrough, and if Senator Perchlik shows up, I'm sure you can just share what the genesis is with this bill. And yes.
Sure. Thank you, Senator Hashim. Eric Fitzpatrick with the Office of Legislative Counsel. As the chair mentioned, here to do a walkthrough of S22. Senate Bill 22 is an act relating to prohibiting discharge of firearms within 500 feet of a child care facility or a school. Just a moment or two of background, because as many committee members may recall, this is at least related to and has some crossover with some statute that is already on the books, both in state law and federal. So in state law, you have a provision right now, it's 13 VSA 4004, that prohibits possession of a firearm or deadly weapon in a school bus or in a school building. So you see, it's different than what you see in front of you in S22 in a couple of different ways. One is doesn't apply to all school property, applies only to a school building or what is defined in that case as school property as well, but it doesn't apply to discharge. You know what I mean? Possession only. So there's going to be some crossover, but they're also very distinct. And the reason for that, a couple of reasons, but one thing to at least know about the existing Vermont law on it, and the way it is written now, prohibits possession in a school building, right? That's pretty clear. School building, possession prohibited. If it's school property, it prohibits possession with intent to harm another person. So doesn't prohibit all possession, only possession with intent to harm. It's on school property. So you see already a couple of distinctions between this and the bill you're looking at. The bill you're looking at only applies to discharge. And it doesn't just apply to school property, it applies to within 500 feet of the school property, in addition to the child care. So you see there's some crossover, but there's also some clear distinctions as to different sorts of conduct that would be covered by the existing statute and the proposal that you're released.
Quick question for you, Eric. I know there might be some schools that have hunting clubs or shooting clubs. They may have property designated for that. Would that be? And I was thinking about something you mentioned regarding the with the intent to harm. So would would those types of clubs be excluded in the event that it's, for legitimate purposes?
For example, a hunter safety class or something of that nature. I think the way it's written now, you would want to be express. And so add that if you wanted to make sure that that type of activity was permitted and wouldn't inadvertently come under the coverage of the bill, you'd want to add that clearly and expressly.
Thank you.
Yeah.
Senator Matt.
Just looking at the definition, school property means any property owned by a school.
Mhm.
Does that include like vans, buses? Because it doesn't say real property.
That's a good point as well. It's interesting. So that the two definitions that you're looking at, which are subdivisions 3 and 4 on page 2, owned by the school and school property, are both taken verbatim from the existing statute that I was mentioning, that says that prohibits possessing a firearm with intent to injure another person on any school property. So that statute as well have definitions of school property and owned by the school. There was an exclusion. Oh, yes, but it specifically provides that in that case, school property includes motor vehicles. So if you wanted to, whatever your policy choice might be, if you wanted to be clear on whether vehicles were included or excluded, then you might want to add that as well.
Yeah, and I'm just thinking, school bus drives by somebody's property and you're 400 feet shooting the other way, you technically probably be charged with this bill.
I think I hear what you're saying, but there is the knowingly standard on line 15 that would apply to presumably, that school bus. I mean, Eric, could you touch on that knowingly standard, how it relates to whether or not somebody should have known that a bus might be driving 400 feet away and they're shooting the opposite direction? Like, would that person be liable?
It's an interesting question, and I think it goes to an interesting question of statutory interpretation, which is, does the knowingly apply to the discharge only, or does it also apply to that you're within within 500 feet of school property? If it were just knowingly applying to the discharge, like I'm firing the weapon, knowing that's what I'm doing, then it could conceivably include the school bus and you didn't see the bus drive by, for example.
Mm-hmm.
But if it applied to the school property one and you didn't see the school bus drive by, then you wouldn't necessarily be prosecuted because you didn't know, hey, that's school property, and I'm firing my weapon within 500 feet of it. And there is a case on that because I remember this issue has come up before. I don't want to say for sure because I'm going to have to relook at it. I think that the knowingly applies to all things. It's sort of distributed. It applies to each thing, so that if you didn't know that you were there, you'd be okay. But I want to double check on that.
Yeah, I think that's a good question to explore a little bit further. I think, well, yeah, we can revisit that. We have Senator Perchlik here. We can pause the Ledge Council walkthrough.
Yeah.
And hear from Senator Perchlik about the impetus.
Right.
Thanks, Eric.
Sure. Thank you.
Morning.
Good morning.
Thanks for coming in. We were just hearing from Ledge Council for a few minutes, just a walkthrough and a start to the bill, but just wanted to hear from the sponsor about what started the bill and what your thoughts are.
Sure. Yeah, so this came about because I went to a public safety meeting in Waterbury, a neighborhood along Route 2 outside of Waterbury. Had two houses that were, for lack of better terms, taken over by drug dealers from not there, and were conducting themselves in all sorts of ways that were basically terrorizing the neighborhood. But so they were trying to find out what they could do about it. The state police were there, the state attorney was there, the town officials were there. Waterbury no longer has a police force. So they were looking for solutions about what they could do about the people that had moved into their neighborhoods that were not being neighborhood. There wasn't a lot of solutions brought up at the time, just because, they were. It wasn't an easy thing that the neighborhood or the town could do to stop it, that the police weren't already working on doing. One thing that they complained about was one of these houses, I was gonna print out a map, but they're next door to each other. So there was one of the residents in this neighborhood has a childcare center, licensed childcare center. And the house that was kind of given up by the landlord to these other folks that were the problem was really like right next door. They're like within 15 feet of each other. They're right next door. They both have land that goes back to the Winooski River that was by. People in the drug house basically would go out in the backyard and fire weapons into the riverbank there. So they were right next to a child care center. So they would be with children there, and also sometimes at night, which is it's not legal. But they were told when they would call the troopers that they were told that because they're on their property, firing weapons is not illegal. They said they were part of targeted practice shooting. And sometimes with, well, at least what the neighbors saw were automatic weapons. I don't know what actually weapons they were, but so the idea came that, well, maybe one idea, because I knew about other regulations we have about firearms at schools, fire hunting regulations about not shooting within 500 feet of a structure if it's posted. So I thought maybe this would be a way to at least have that problem be solved. Yeah, so that was the impetus of the bill. And the child care provider is willing to testify and talk about if that there was a bunch of other problems. There was a shooting at the house recently, which has caused them to vacate the building. So now it's empty, but they're just kind of worried that could just be temporary. And at the very least, they don't want, the discharge of firearms. Yeah. That close to their job.
I think that's definitely a very valid concern to have regarding everything you just described. I think some of our very initial conversations, we're just trying to get some more nuanced detail about school properties and, any schools that might have, like a hunter safety course, maybe some land that they go to, would that be school property? And are they, but they're just going to practice for legitimate reasons. And then, the situation of, is the school bus considered school property? And if somebody is on their own land, shooting in one direction, 400 feet, school bus is driving by, are they liable in that circumstance? So I think just getting some more, I think we might work on some of those concepts a little bit more, if committee wants to move forward with this bill, but to the issue that you're describing, I think that's a very reasonable thing to bring forward.
Yeah, when I brought the bill forward to Village Council about childcare, they brought up the connection to the statute about schools, and I was surprised there was no definition of the school.
Yeah.
But yeah, be happy to look into that. Seemed like there could be some clarity down about the school, or the existing law about firearms and school property.
Senator Boski, did you have your hand up? Senator Boski.
I have to wait. Senator, first look about. I gotta tell you, honestly, I understand the intent and the concern of the particular bill. But now we're telling you, if you look at the school, say where I live, they don't allow property that goes up, that butts up to somebody else's property. And now this bill is telling them that they can't discharge a firearm well in excess of 160 yards from where that school property starts. So that's going to run into the problem with our.
Yeah, and I
and whatever else going to come in here. So I think there should be a happy medium here or compromise.
Yeah.
160 yards is a long ways from school property. You measure your backyard there, it's probably not 160 yards wide. So you're impinging upon somebody else's property at this point in time. I'm not saying it can't be done. I'm just saying those are my concerns.
Yeah, and I asked Village Council about that, about what the constitutional issues we might get into, if they're just on their own property, somebody just happened to have opened a childcare next door, are we saying they can never fire a weapon on their own property? I think it's a good, fair question for this committee to try to figure out.
Yeah. Excuse me.
Committee, any further questions for Senator Kirchler? Great, well,
Okay.
thank you.
Great, thanks for taking the test.
Thanks. You can, keep hearing from Eric. I don't know if, you had a chance to finish your, walkthrough of the bill.
Well, one thing I did want to thank you and Eric Fitzpatrick with Budget Council back again, continuing to walk through on S3 or S22, sorry. Was just so that the committee knew the existing background of law with respect to firearms and schools. And you may recall this from prior years, that there also was a federal law. It's called the Federal Gun-Free School Zones Act. And the federal law prohibits possession of firearms within 1,000 feet of school grounds. So there is a federal law on this that would cover some situations as well. But also there's a number of exceptions in the federal law. So that's the reason that it's similar but different. You know, federal law has exceptions, for example, for a person's license. If you're licensed firearm, whether it's just licensed to possess or concealed carry. Some states have concealed carry licenses, but mine doesn't. So if you're licensed or if you've got a firearm under safe storage, in a lockbox or securely stored in your vehicle, that sort of thing, there's exception there. So there's a number of exceptions to federal law. So it's not exactly the same as this, and wouldn't cover all the same types of activities. But I just wanted to know also that there's federal law in the background as well that sometimes would cover similar situations. As I was thinking about the point about motor vehicles, that sort of thing, possibly, assuming that committee wants to, look at further drafting options at some point in time, which you obviously still have to think about. But an option for that might be a page 2, line 11. You're getting at this line 13. You could specify that to be school property means any real property owned by a school. So that way you'd be clear that it wasn't applicable to a vehicle. It's an option.
And then right above that, line 11, owned by the school means owned, leased, controlled, or subcontracted by the school. So if you subcontract with another agency that, I remember when I was in school, we went to the bowling alley. Would that mean anything around that bowling alley at that time? Because you subcontracted with them to use their premises? Would that fall into it?
I think it would depend upon the nature of the contract, but possibly. And that is the language that's in the existing statute now regarding possessing a firearm. Now, the difference is that under the current statute, what prohibited, if you're talking about school property as opposed to a school building, is possessing with intent to injure. So again, let's sort of game out that same situation.
Yep.
In that case, it would apply, but it wouldn't apply just to possession. You'd have to be intending to injure something.
But in case of this bill, knowingly discharging
Correct.
fire.
That's right. So maybe because this is a different situation, you might want to limit it in terms of subcontracting, that sort of thing, because you don't have the intent to injure component in the bill.
Right. Right.
Right. I think that's for purposes of the walkthrough. As Senator Kirchler mentioned as well, you'll see, in the definition section, you may notice that there's no definition of school, and that's intentional because not as the education attorney in our office, I asked our education attorney, hey, we have this bill. Is there some existing definition of school that I can cross-reference for purposes of this bill? And she said, well, actually, there isn't. That's not as easy a question as you think. It's more complex than that. So rather than trying to find a school in the criminal code, it didn't seem like the right place to do that, especially since, again, the existing firearms in school statute also doesn't define school properties, but not school. So it seemed like, given all the, from what I hear, schools is a topic elsewhere in the legislature, this didn't seem like the right place. Yeah, that's the word I've heard. I didn't seem like the appropriate place to define school in the criminal code for firearms.
Yeah, another question.
That just opens up another can of worms, because I was gonna ask about the definition of school.
Yeah.
Now I'm thinking of homeschool and what that means for, if you're like back to Bob's point, people have a bunch of land in Franklin County and somebody homeschools their children and you're right next door, and how does this law play into that? Based on that.
I mean, I think it could be fairly straightforward to state that, a school will be categorized as either a public school or an approved independent school, and, have it applicable to those places, or licensed childcare facility. Well, we have the definition for that already.
Right.
Yeah. Okay.
Yep, that's certainly an option. And there was a similar route that was taken in the I think it's in the hazing statute. That took a similar route. So you could do that as well, say for these purposes, this is what it's gonna be. Regardless, we're not trying to get into what other situations, right?
Yeah. And I think also trying to figure out that knowingly standard, if you're, like with the example that Senator Perchley provided, that you're right next to a daycare center, especially if the cops have visited you and said, hey, knock this off. But there could potentially be some issues if you're in the middle of the woods, 400 feet away, there's a childcare facility that you don't even know exists. It's just somebody's house, but they do have a license to be a childcare facility or neighbor. Visiting that standard and perhaps figuring out what type of language should exist there. Yeah, would also be necessary.
Yeah, I will look into that, because I remember a case that's exactly discussing that kind of statutory interpretation question of whether the knowingly, like what elements of the crime did the knowingly apply?
Yeah. Committee, anything further? Okay. All right, we can